Welcome back to the Legal Alternative Podcast. Me, SamPawson, joined in person by Nils.
Yeah.
Nils, how are you?
I'm good. Just back from Portugal.
Lovely.
Factor 50 sun cream did its job.
Yeah, can see.
Yeah.
We'll catch up later on what we've been up to, but I think it's first in person for a while, so it's nice to be back in person. I think you're kicking us off since we've been away. We've had the King's Speech. So
Yes.
a few updates from you.
Yeah, I actually think they're really interesting. Government has said biggest changes to the court system in a generation. I actually think it's probably, you could go further back than that. So King's Speech has proposed a courts modernisation bill.
Yeah.
Removes the defendant's right to elect Crown Court to trial in either way cases, with the venue decision now resting with the court. We discussed that on a previous pod, which is really interesting. New bench division will hear either way cases, where they will attract sentences of 3 years and less. And complex fraud and financial cases are now going to be heard by a judge alone, which is, if you are a financial crime defendant, a fairly significant development, or a financial crime solicitor. What's powers extended from 18 months to 24 months. Some huge changes there.
Yeah.
I think they're really fundamental, actually. Really fundamental. I think it'd be worth back to them in maybe 6 months' time. I think the Crown Court changes, the new bench division, really significant. Some other changes, Public Office Accountability Bill, which is what's the Hillsborough Law commitment. So new obligations on public bodies and officials relating to misconduct in public office, backed by a new criminal offence for non-compliance. Given, I think Hillsborough might have been either just before or just after we were both born. Surprises me that it's taken such a long time for something like that to get on the statute, or proposed to be on the statute books. National Security Bill, which updates the Computer Misuse Act. So a new crime of cybercrime risk, to place controls on cyber criminals, new search powers, I think, in today's society, really important. And then the Tackling State Threats Bill, which I won't go into, but new sentencing powers up to 14 years for those who benefit proxies of terrorism. So I think for what we do, most significant are the modernisation bill, and the others are really interesting. But I think that the court's modernisation bill, really significant change to our criminal justice system.
Absolutely. And I think you're slightly ahead of things we talked about in the past in employment. There's more consultation in the employment courts about bills that are going to be similar, which is essentially looking to create more divisions to put claims, in a lower court, essentially, or where it is held by a judge or a magistrate equivalent in a tribunal, to try and get to backlog, which we've all talked about. This balance, in a way, when we talk about access to justice, when we're balancing time versus, as you've talked about the previous podcast, some kind of Magna Carta-esque rights to tried by peers. I think that was, when we last spoke, that was one of your more controversial takeaways, the judge only. For those fraud cases, it's big development.
It is. I think the change I really like is the bench division. I think that creates another layer which will speed things up. We'll wait and see. I am a previous views without getting non-political, I hope, previously, but I think the right to elect the Crown trial, really important right in this country. So it'd be interesting to see. I'm not political, really. I would be surprised if that isn't fought quite hard in both Houses of Parliament. Let's see if it gets through. I personally think that'll be fought quite hard. I might be surprised if that gets through. I think it's that fundamental, but we'll see.
Yeah, or watered down to such an extent that it's only for those kind of minimal cases.
Yeah.
But no, interesting to see, and I think backlog of probably what we're both going to be talking about for the next year or so. Changes to the system as much as the law. Just interesting times ahead.
Yep, absolutely.
Again, I'm going to talk about a case, bit of a headline grabber in terms of levels of compensation, but as always on the pod, as we dig behind things to try and give some explanation. So it's a case of Jones and Pilkington UK, glass manufacturer. You've got an employee with very long service. So this employee started in 1983. So again, before both of us were born, and who has some quite serious disabilities and medical issues. So claiming in this case, just quick background, high dose radiotherapy in the 80s after developing Hodgkin's lymphoma. That caused a condition called neuropathy, which is, as you probably know, Nils, a chronic condition which results in muscle wastage. So this affected his right shoulder. As a result of that time, duties, obviously in a glass factory, quite manual labor, they've been over time reduced to remove the kind of manual elements of the role. Significant sick leave during employment because of that shoulder pain. Other conditions then linked to those physical health problems with some mental health conditions, stress and anxiety at work. Whilst on a period of sick leave, the claimant was viewed by a fellow member of the company in a local shop wearing work boots. That was then reported to the company on the suspicions that this person had secondary employment and was carrying out, theoretically by the sight of the work boots, a physical job of some form.
Right.
As a result, and again, in my view, which you could think come obvious, quite a leap, the company then instructed a surveillance company to track the claimant, and he was found to be on one of the claimant's friend's farm, where he was seen carrying out forms of manual labour, including passing bags of potatoes and other kind of farm products to colleagues and friends. He was then invited into a disciplinary hearing, and on the basis that he had secondary employment during sickness absence and was also dishonest in his medical opinion, or his opinion that he couldn't carry out physical labour. As a result, claimant dismissed for gross misconduct, claims then brought for unfair dismissal, disability discrimination and breach of contract linked to the obviously claims of gross misconduct. For me, rather unsurprisingly, I'll come into the judgment. All the three claims were upheld. The tribunal found that the key issue here is, yes, the company obtained that surveillance, but as a result of that surveillance have not then obtained any further medical evidence to actually attest to what is the heart of this.
Is he fit to work?
Is he fit to work or not? There were also failings in the allegations, split between these two quite separate things, which are secondary employment, which it wasn't clear he was on a friend's farm, and being fit to work while on a period of sickness. This is a classic case that we do see of companies rushing to judgments and probably being extremely upset by seeing someone who is supposedly off sick doing things. I don't know if you probably had this in practice as well, Nils, but I've had clients who get very upset where, for example, people may be off sick with stress or physical issues, and then they're put on social media that they're at a theme park or they're doing things. And there's this view of some companies that if an employee is unfit for work, that means they must be in bed at home doing nothing. And often where you have mental health conditions linked to physical conditions, lots of medical advice and the views of the tribunal is actually that's beneficial to them.
Get out and do something, yeah.
And held in evidence by the tribunal that actually the visit to the farm may have had positive mental health to the individual. Ultimately, claims upheld. The tribunal found that the decision to dismiss on the grounds of gross misconduct didn't fall within the band of reasonable responses, which we've discussed at length in various podcasts. 4 awards were made. Example of what we're talking about here in terms of tribunal backlog. This is a case that was heard in 2021 and the remedy was finally heard in February 25.
Wow.
So we've got a reporting on remedy now for a case that is already kind of 4 or 5 years old. Quite, again, a highlight of the backlog in tribunal. The big takeaway on awards and why this has got some press attention is that the total compensation here is £329,000. So, in the relatively modest world of the employment tribunal, a huge award. Of that, £31,000 were in injury to feelings linked to the discrimination. So we've essentially got just short of 300,000 in loss of earnings pension. This was a case you can probably allude from the individual's start date. He will have claimed that this is a retirement
career-ending
issue. So it will be much over a year's compensation, which we can be because it's a discrimination claim. Yeah. We're not capped. Again, lessons in terms of future updates where we're seeing the removal of the statutory cap for unfair dismissal. You may see these type of awards becoming normal. So few real takeaways, and I'll get your views on it. Real for me case of the importance of not rushing to a judgment. Something may really upset you as an employee. You get this with social media cases a lot where employees post something inflammatory or comments that you wouldn't agree with yourself, and you rush to a dismissal. Again, a case that they completely rushed to, probably won the decision to get surveillance, but even more so, even with that surveillance, then to move immediately to dismissal without medical evidence. It's a recipe for disaster in essence. And again, clearly shows the absolute financial remedy if you get this wrong. Don't know any else.
No, I mean, it should have been step A, shouldn't it? We've got this surveillance. Can we send that surveillance along with the individual to occupational health and say, is this consistent with an individual who is purportedly unfit for work? If it said that, I can see why it would be annoying. It would be really annoying if you think someone's off sick and they're potentially working somewhere. It doesn't even sound like that was particularly clear they were working somewhere else, but I think it's about building a wall, isn't it? I understand the frustration, but yeah, I think it's a very valuable lesson there.
Yeah, absolutely. And that frustration with the individuals who are potential long-term absence. Again, it's I think if this company came to us, we would be looking at a much earlier stage at whether this employee is capable of performing their role. Lots of adjustments have been made. Doesn't mean those adjustments are valid forever. Ultimately, a question of is this employee capable? There can be quite a valid judgment of, sadly, he's not capable, and as long as we follow that correct process, you would then never no risk, but you would be in a better place to look at potential dismissal. Again, it's a case in reality. I'd be saying, can you be looking at some form of settlement here? Doing it, they've cost themselves.
I think the beauty of medical evidence as well, it's independent. For the employee to win, they've got to, I've never seen this done, show that the doctor was wrong. And that's really difficult.
Absolutely.
So it would have actually been so much easier to completely park it, really, when you think about it.
I think if, again, it's without getting into details of the case too much, that's of workings for a third party. You then need to look at it contractually if you can do that. That might have been a clearer case, but again, it was not clear from the evidence he was working. He was probably helping a mate out on his farm. So again, lots to unpick. An interesting case nonetheless.
Reminds me of going to the old St Helens ground. I think you could see the Pilkington factory from the away end.
Absolutely. Yeah, and out the office, back from holiday, bit busy as ever.
Yeah, absolutely.
I've been in sunny Darlington, Chadwick Lawrence's new office. We had our first seminar there, presented by our colleague Daniel. Really good event. I had an employment update, so really good new, obviously, area for us. Really exciting development for Chadwick Lawrence. Great to kind of take our our show up to the north of England. So really exciting development, other events coming on. So exciting times for us, and similar in your team.
You won't mind me saying now, Simon has joined, Simon Cattrall up there. So 40 years experience in regulatory and crime, absolutely massive asset to the firm and the team. And it's nice to start to put roots down in Darlington. He's made a big difference to our team and clients love working with him. So yeah, it's been a really good start in Darlington.
Perfect. Exciting times ahead. Good to be back in person. And we'll be back this week with usual updates. Lots more to get through, both on legal updates and some case law. So we'll be back next week. And it's goodbye from me.
And from me, thank you.
Welcome.